Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today we are going to discuss a case law on the right of private defense. That too, the judgment given by Jammu and Kashmir High Court. Normally, even though we plead the so-called right of private defense umpteen number of cases, normally the court will not allow 90%. But here it is one case where it has been allowed by the Honorable High Court. Of course, lower court did not agree. So here the heading goes like this. The object of investigation is to unravel the truth. In other words, as a police officer, when I used to address the young officers, I used to tell them, so the purpose of investigation is to reach the goal of truth. Truth is the goal of investigation, to unravel the truth. Of course, normally, as per the crpc, investigation means all the proceedings conducted by a police officer, so to ultimately to reach the goal of truth. And secondly, please remember, the accused, even though the investigation, please remember, the investigation part, the investigation must go to find out whether the accused is innocent or not. If the accused furnishes certain documents, definitely you have to take them. Of course, if they are useful for the investigation, you can take them, otherwise you can drop them out. But you cannot drop out using the powers under section 91 crpc. So this is what is held in the case of Ajay Kumar Agarwal versus State of Union Territory of Jammu and Kashmir, 2022. Right? Single Justice Sanjeev Kumar, he held that. So the object of investigation is to unravel the truth. Right? So in this case, let us go to the facts of the case. Facts of the case, our man is not an ordinary man, Agarwal. So the allegations against him are that he used to threaten the high-profile business people in the name of so many fake cases, and that he will encounter them also. It is quite common in Jammu and Kashmir. And he used to extort money from the business people. So these are the case of extortion, or normal in other languages we call it as blackmailing. He is a very good blackmailer, and in his hands so many people suffered. Some of them kept mum, and some of them, one of them daringly, he has approached the police and he has reported the matter, and now it has come to notice. Then, when he was arrested, this is the main problem. When he was arrested, the accused, or this J. Kumar Agarwal, he said that he has documentary evidence to prove his innocence. So therefore, he has furnished certain documents, but the investigating officer avoided the same, neglected the same, refused to receive the same. Suppose if these documents were produced before the court, his innocence would have been proved to some extent. But the investigating officer outrightly rejected to take the documents or material evidence. Here the impact. So therefore, he has to approach the trial court. Trial court also did not agree. Ultimately, when he came to the High Court has agreed, because Article 21, right to life and liberty, Article 20, one should not be unnecessarily involved in all the cases, in two or three more cases like that also. So it is against to Article 21 and Article 14. So the purpose of investigation is to unravel the truth. For unraveling the truth, he has to examine the witnesses, he has to examine the accused, he has to find out whether the accused has got any plea of alibi, whether he has got any defense. That should also be taken into consideration. Otherwise, what is the purpose of investigation? If you go on, suppose if a case is registered, you go to the scene, you will examine the witnesses, you will record all their statements, and you come to the police station, file the charge sheet against the accused. Are you not going to hear what he says? You have to. That is the purpose of investigation. You have to inquire him. You have to see whether he admits the offence or not. Even though he admits the offence before you, Section 25 of the Evidence Act comes as a bar. Is it not? You know all these things. So whatever documents or whatever material evidence is put forth by the accused person, the IO has to accept them. But at the same time, if they are useful for the investigation, if they will be useful for the accused, definitely they have to produce it before the court. If not, in all fairness, they can reject the same also. But it has to be on record, is it not? Here what happened is, even though the accused stated that he has so many documents and he has produced before them, the IO outrightly refused them. Now, the Honorable High Court has directed the court to take all these documents and hand over to the IO. The IO will go through the documents by giving acknowledgement, and if they are useful for the investigation, he can file them, he can get them marked. If not, he can reject them, but reasons should be given to the accused person. No doubt, normally when you see the case, after all, why should you support a smug, a so-called extortionist or a blackmailer? But in the view of law, in CRPC, in the entire rule of law, the accused is supposed to be innocent till the guilt is proved against him. If at all, whatever documents he produces, definitely you have to take them. Of course, if they are useful, use them. If they are not useful, you can reject them also. That's why in section 173 CRPC, at the time of final report, the prosecution can file the documents on which it relies. The prosecution need not file the documents on which it does not rely. That chance is there for the IO. But rejecting the documents is itself not a correct idea. So that is what is told by Jammu and Kashmir High Court. So friends, remember, to conclude, I want to tell you, if any police officer sees this video, please give a chance to the accused to explain his defense. Give a chance him to give his documents. Otherwise, he will produce the same in the court. Why is he giving a chance to the court? And of course, if you are not satisfied, nobody is going to object, because investigation is the power given to the police. You have got all the powers. You can reject certain documents also. But not taking them on file, this is the main problem, which you should not do. So please read the judgment and enrich your legal knowledge. Thank you very much.